for that.
So what you said before about the press sometimes blocking free speech, it kind of reminds me a little bit of the conversation that's going on right now about social media and the claim that social media is blocking and censoring conservatives on all of the social media platforms. And they, to a certain extent, deplatformed a more conservative leaning social media app, which is Parler. Um, you know,
Yeah.
so a lot of people that I tend to listen to, because I kind of somewhat hang out in the libertarian circles. It's more closer to my political philosophy. So there's kind of a divide within those circles because the typical libertarian philosophy dictates, hey, they're private businesses. They can do what they want. You don't have to use their platform. Other people can start new platforms. But then there's another faction that says, you know what, I'm sorry, that sounds great, but it doesn't quite meet the challenge here, because the reality is Twitter and Facebook and Google and YouTube, they are the press now to a certain extent, and they are the the public square. So there's even libertarians now that have gone on the bandwagon of, we need to regulate these platforms. What would you say about that?
Well, I think it's a bit dangerous to try and regulate platforms, but censorship certainly should be resisted. And the fact that Facebook, Twitter, and these other platforms are blocking conservative views, I think is certainly wrong. But whether they should be controlled by whom, then that's the ultimate question. Who's going to control them? And I think the internet is broad enough to allow conservatives to have their own platforms. And it seems to be the case that the airwaves, as far as radio is concerned, are, I won't say dominated by conservatives, but there is a very strong conservative presence on radio, but less so on television, and probably less so on the internet, the sort of mainstream internet that you mentioned. But it is a tricky case, and question of hate speech. Is there such a thing as hate speech? And should there be? And should it be illegal? That is a very major question. It's not an easy one at all, but it is becoming, political correctness has crept in so many ways that words, even perfectly innocent words, are now banned. And that applies to even things, well, the word niggardly, for example, was banned a few years back because people assumed it had something to do with the color of a person's skin. It has nothing to do with that, actually, nothing whatsoever. It's not connected etymologically with that at all. But because it sounded like it, and anything similar to that.
And in the UK and in Europe in general, there are a lot of pretty, I would say, extreme, I don't know if you would agree, but extreme hate speech laws. I've heard stories of people getting arrested because they posted something that was deemed racist or offensive or whatever, discriminatory on Twitter, and a couple hours later they get a knock on their door by the police. Is that true?
Yes, I don't know about Twitter, but but certainly, I mean, I was quite surprised when a firefighter, you're not allowed to say fireman anymore either, because some of them are women, so a firefighter told me that in his fire station in England, this is, you're not allowed to order a black coffee or a white coffee because that is racist.
Wow.
Absolutely nothing to do with race.
Wow.
Of course. It's the
Wow.
color of the coffee.
Jeez.
Whether it's got milk in it or not. What has that got to do with race?
Yeah.
Nothing. But he was up in arms against that. But he said, you've got to be careful. He could lose his job over that.
And the question is, where does this end? You know, so.
Yes, well, that's right. The thought police
Yeah.
do have there is a law in England called the Malicious Communications Act, so that you can go to jail for if you make what is considered by the courts to be a malicious communication. What's the definition of that? There's no actual proper definition.
Yeah.
For the courts, and that's the trouble. The courts tend to be very politically correct.
Yeah. No, that's some pretty scary stuff as far as I'm concerned. And from what I understand, it's pretty prevalent in Canada as well. So, but
That's so, yeah.
Yeah. All right. So let's move along. Another famous case that fits into the First Amendment category is the Christian baker versus the gay wedding cake.
Oh, yeah. Well, I've written about that separately. I don't know whether you've seen
Oh,
that.
no, I did not. So that's great. I'm glad we're touching on this. Now, when the last edition of the U.S. Constitution for Dummies was published in February of 2018, a decision was not yet made by the Supreme Court. But since then it has, and they sided in favor of the Christian baker. So what's your take on that?
I think that was correct, but in fact, a similar case existed in England, but there the result was different. I think if you are a business, you surely have the right to accept custom or not. And if they want you to write a slogan on a cake, if you're a baker, all right, you don't have to accept every offer. Someone asking you to do a wedding cake, you can refuse it on any grounds. In this case, they particularly didn't want a wedding cake for gay weddings. And what was more to the point was that there was a slogan on the cake which indicated that they were advocating gay marriage. Now, they may say, well, look, we accepted that contract, but purely on the basis that we were carrying out the instructions of our customer. We don't necessarily agree with that. But how is anyone to know that? If the message on the cake says support gay marriage, then it's assumed that the bakers are in tune with that also. And so I can see no reason why they can't refuse it, because you are then being forced, a slogan that you don't agree with. And that's exactly the opposite of free speech. You're actually being denied free speech because you're being forced to speak in a way that you don't agree with. And as far as the customer is concerned, there will be people, and of course there were, other bakers who are prepared to bake a cake to those specifications. There will be, and there were. There was an earlier case, which I've written about, and I think it's been forgotten, much, much more trivial case, which actually made that point, and the Chief Justice at the time actually made this point, that this was a case about New Hampshire, where the the car, the number plate of the car in New Hampshire normally carries the state motto, which is, what is it? I always rather twist it. Die. What is it?
Live free or die.
Free, die young. I always say.
Okay.
Not live free, die young, but live free or die. And this one person said he refused to put that on his car. He blacked it out. But the state said, no, no, that's not valid, because that is the standard number plate that we have in the state. That's issued by the state. You're not free to diverge from that. But the Supreme Court said you are, because as he put it, he was being forced to utter a slogan that he didn't agree with. It's harmless enough, but he didn't happen to agree with that proposition, and therefore didn't want to be forced to put it on his car. And the Supreme Court agreed. And I think they were right to allow him to not to associate himself with that if he didn't want to.
So
it's forced. That's forced speech, really.
Yeah.
Forced speech.
Yeah, definitely, without a doubt. So the Christian Baker again, was that cited on behalf of his religious beliefs, or was it cited on behalf of freedom of speech? Because I thought it was based on freedom of religion.
Well, it is really.
Okay.
Yes.
Okay.
The freedom of religion, freedom of speech link up here.
Got it.
But
Okay.
freedom of religion, yes, that in a way you're being forced to renounce your religious views and express views which are contrary to them.
Yeah.
Because these Christian bakers were completely, of course, to them, gay marriage is anathema.
Yeah.
Contrary to the Bible, it's contrary to their religion, it's contrary to God, according to them, and therefore they wouldn't want to be associated with it. But if it's on the cake, they are associating themselves with it. Yes.
And this is a case. Now, I tend to fall on the side of thinking I probably would prefer the Bill of Rights not be incorporated, because I think that just brings the federal government into our lives that much more, even though sometimes for the better. But this is definitely a case where it worked out in this guy's favor, because the entire state was against this guy at every level. And if it wasn't for the Supreme Court, you know, he never would have found what I would call justice. So the fact that the First Amendment is now incorporated actually saved this guy. So,
well, yes and no, because many states have got a similar thing in their constitution anyway.
Yeah.
So
okay.
That wouldn't necessarily have depended on the federal constitution if it was in the state constitution.
Yeah, but this particular state, his back was up against the wall from everything I read about it. So,
right. Yeah.
So getting back to the Supreme Court, okay, in Chapter 14, you write about a Supreme Court ruling on two different cases involving the display of the Ten Commandments in front of a courthouse.
Oh, yeah.
Now, the first case, it was deemed in violation of the First Amendment. But in the second case, it was deemed permissible. So what's up with that? Well,
they made some minor distinction between the two, as I recall.
What's that?
The one in a park, and the other was in a courtroom, I think. Yes, and there are minor distinctions, but in reality, again, it's about freedom of religion and freedom of speech. And if it's in a courtroom, you could say, well, this is an imposition of these laws from the Bible on people living here today who may not always be bound by them. I mean, certain of the commandments are certainly not generally obeyed, like Sabbatarianism. At one time it was much more common. Now, I mean, Orthodox Jews are very, very careful about not working on the Sabbath, all that, and there are some Christians who feel the same way, but the majority of people do not feel bound by that law, for example. Also, even the first commandment about having one God or believing in any God is not something which you can force on people. So the Ten Commandments are a beautiful summary of some of the most basic tenets of humanity. Thou shalt not kill, thou shalt not steal, for example, those, love thy mother and thy father, honor thy mother and thy father. Those are wonderful, but the others cannot be imposed on people willy-nilly. So in a sense, I think you've got to be a bit careful with something like that.
Oh yeah, definitely. And I agree. I would fall on the side of, you know, if it's disclusionary or offensive or whatever, like why are we even doing it, you know? So my point wasn't so much in defense of having the Ten Commandments on display at a courthouse. My thing was just more like, you know, in one case they deemed for it, in the next case they deemed against it. It just seemed kind of arbitrary.
I'm not sure I think it's in my book, but I'm not sure exactly what the distinction was that they drew. They did make some minor distinction, but I think that was more of a distinction without a difference, as it were.
Okay, so there was more to the story then.
I would say in a courthouse it is more dubious, because it's not really part of the law of this country. Whereas if it's displayed in a park outside somewhere, I can see no reason why that should not be the case. Because it's part, on the other hand, while it's not part of the law of the United States, it is part of the general tradition of the Abrahamic religions, of the Judeo-Christian ethic, and is accepted in that respect by Jews, Christians, and Muslims. But not everyone is a Jew, a Christian, or a Muslim. You don't have to belong to any religion. And you may be offended by something which says thou shalt have only one God. You may not have any God, or you may have lots of gods.
Sure. No, I agree with that 100%. Now, in chapter 2, you quote Thomas Jefferson as saying, the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary.
Yeah, well, that's part of his attack on John Marshall. It's really a reaction. That really is a reaction to the Marbury versus Madison case, which really rankled him very badly. But he never had the guts to take action against Marshall, frankly.
And in chapter 2, you also quote
He's right. That is what has happened. The law has become a thing of wax in the hands of the Supreme Court, and we've seen that just lately, particularly in the last 20, 30 years, particularly.
So, and also in chapter 2, you quote Justice Charles Evans Hughes as saying, we are under a constitution, but the Constitution is what the judge says it is. So what did they mean?
But he went further and said, and the judges protect our property and lives and so on. He actually was in favor. So that quotation is usually taken out of context.
Oh, okay.
I think I put the full quotation there to indicate that he actually was in favor of it, because he became Chief Justice. He didn't say that at the time. Well, this was much earlier, but he later became Chief Justice. So, of course, he agreed, actually, that the court should have that kind of power. It's not an attack on the court's power. It's a description of it, but he actually agreed with it.
Yeah.
But it's true. It is true, unfortunately, because the court was never intended to have that power, as Thomas Jefferson always insisted. And I would go with Thomas Jefferson on this rather than John Marshall.
So can you explain that a little further? What is the problem with the court having that power of judicial review?
The first problem is they're not elected. The second problem is that they're there for life, and therefore they can be they can be dictators. And the fourth problem, is that they don't agree. That there's no agreed basis of constitutional interpretation. So that you have someone like Antonin Scalia, who was an originalist, who would take the words of the Constitution as they were written there and take them very literally for the most part. And then on the other hand, you have Ruth Bader Ginsburg, or one of the other liberals, who would say, no, 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 the Constitution is a living document, the living Constitution. And therefore we have to interpret it in accordance with society as it is today. Just because they didn't have any conception of gay marriage in 1789 doesn't mean that we can't have it now, or any conception even of privacy. There is no right to privacy in the Constitution. That has been created by the Supreme Court. The right of abortion is another of these rights. Certainly doesn't exist there. Now there, actually, Ruth Bader Ginsburg had an interesting take, because she said that she thought that it was very heavy-handed of the court in Roe versus Wade to wade, make a bad pun, to wade into this question, because she thought this was really a question for the electorate to decide. And she said she felt that at that time, which was 1973, the feeling in the country at large was moving towards abortion rights and should have been left to the state legislatures to legislate on. But for the court to make law in that way, which was very heavy-handed, she was actually against. She was in favor of the principle, very much in favor of the right of women to have abortions in those circumstances, but she was not in favor of it being done by the Supreme Court, surprisingly. Most people don't know that.
Yeah, I read that in your book, and it also said that she thought that it just caused more conflict.
Well, right.
Yeah.
Because in Britain, for example, that's one of the areas where British law has actually proved superior, because there it came about as a result of an act of Parliament, which became law as a result of the very, very incessant hard work of one backbench member of Parliament who kept bringing it forward, and it became law. And once it became law through Parliament, there was very little dissension. There has been very little argument about it since then, very little. Very few cases have ever come before the courts in regard to abortion. Very few. I think because of that, it's got the democratic stamp of approval with it on it, which I think is correct. But for a court to make law in such a blatant fashion on something so important, and something which really isn't part of the Constitution and shouldn't be, I think is completely wrong. And also, I think it's a wrong interpretation of the law, because why is it that that is regarded as being a woman's right entirely, maybe with her doctor, but not her husband? The father has absolutely no rights. There was an attempt at one time to bring that in America, and to say that the husband must have some rights as well, but that was completely defeated by the Supreme Court. The husband has no right whatsoever, or the father. And I think that's wrong, because to regard an question of abortion as being part of a woman's body, I think is in itself a mistake. Whether or not you regard fetuses as having any rights of their own, that's a separate question. The unborn child, whether you regard that as murder, I mean, that's something else perhaps. But I think it's a basic thing whether the father should have rights.
Yeah, no, I can relate to all of that. I have my feelings on abortion as well. I would probably side closer to the pro-life side.
Yeah.
But what we're discussing is, how did this law come about? And I agree with you. And Ruth Bader Ginsburg agreed with you that it probably wasn't the best way to put it into place.
Well, it was used as an extension from privacy, which in itself isn't there.
And all of these supposed rights that aren't actually in the Constitution, for the most part, come about through the Supreme Court. Is that right?
Yes, they have.
Okay.
They have.
Okay.
Of course, the woman who brought the Wade versus Roe later turned against it and said that actually she wasn't pregnant and she'd been pressured into bringing it to court.
Yeah. Yeah. So I want to move right along because we are running way over. But I got at least a couple more things I want to try and get through if we can. Let's move on to the Second Amendment. Okay. So there's no shortage of controversy and confusion surrounding this little amendment. What's the deal with it?
That's one of the examples one could give of where the Constitution is not clear. The language, partly old-fashioned language and partly just the drafting, because was it meant to apply only to a well-regulated militia? That's what it says. Or was that just like a throwaway clause, and it actually is a right for all citizens? Well, now it's been interpreted as meaning it is a right for all citizens. But in fact, there are restrictions on it which are still allowed. There are states where there are laws that do restrict the type of gun you're allowed to own and in what circumstances you're allowed to carry it and so on. And I think that's probably correct. I mean, like Washington, D.C., which was not a state, they have quite stringent laws. And other states, very, very few, if any. So whether it was originally intended to apply to everybody, not clear at all from the wording. Scalia thought that was the intention. Stevens, who actually also, I mean, he was, on this point, he was a liberal, in other words, against the right. He went through the history of it as well and came to an absolutely opposite conclusion. But in Britain, there's never been a total right to possess arms for the ordinary citizen. You have to get a license.
But even Scalia, who was the leader of the individual rights school of thought of his time, even he said that the right to bear arms is not unlimited.
No, exactly. And I think that's correct. I think there should be some restrictions. I mean, should you be able to carry a cannon around with you? Probably not.
So yes. Is the part about shall not be infringed also not exactly what it sounds like?
Well, yes and no, because infringe what? it depends what right you're talking about being infringed. You don't know where you're starting from. Are you starting from a position where this is a right attached to a militia, which is really, I suppose, the National Guard? People today would equate that to the National Guard of today. So that if you're in the National Guard, yes, then you have a right to possess a firearm, which you can keep at home, like in Switzerland. In fact, you have to. In Switzerland, all males are called up to the army, 2 years service, compulsory military service, and they have to have a rifle at home, in readiness. They have to. But that's all tied to military service. Is that the case in America? In which case, it would be to do with the National Guard. Or, as is now the view, the law, does it apply generally? It's nothing to do with the National Guard. So, infringe what? That's the trouble. Like with the First Amendment, the word the, infringe the.
Yeah.
Abridge the right that already exists. You've got to know what already existed.
Mm-hmm.
So I think what's come out of the Supreme Court over the Second Amendment is probably correct, with that caveat of Scalia's that there've got to be some limits. There've got to be some limits. Okay. And but of course, there's also this problem of who to blame, because of course those against Second Amendment rights say this is all the fault of the NRA and of those who make money out of selling firearms, and it's contrary to the ordinary citizen, and it's caused a lot of murders. And of course, on the other side, it said, well, no, guns don't kill people, only people kill people. And what surprises me is that there are no proper precautions taken. The most obvious thing is to have a metal detector in every school at the entrance. It's not an expensive thing. You're not paying retired police officers to come on duty, you're not training school teachers to become security officers, which is something else people have been talking about, which I think is ridiculous. You'd have a metal detector in every school. I can't understand why that isn't done. When you go to an airport, when you go to a public building, you expect to be frisked, or not necessarily frisked, but you expect to have to go through a metal detector and to have some security precautions. Whereas in most schools, universities and ordinary other public buildings are not exactly belonging to the government, there's nothing like that. Now, why? It's an obvious thing. Even shops maybe should have that. But it's not, that's not a great imposition on freedom, and that will cut down this murder rate tremendously, tremendously. You don't need elaborate precautions where people are talking, oh, you've got to train up a lot of teachers. Hopeless. No teacher wants to be a security guard. That's not their job. Or we've got to bring in a lot of police officers or retired police officers. Nonsense. You may need one operator standing by the machine. That's all. And make sure you have as few entrances and exits from any building as possible. I can't see anything wrong with that. I mean, there was a case with a synagogue recently where a man, the perpetrator, as it turned out, tried one synagogue. He realized that synagogue was all locked, secure. He went on to the next one, which was all open. Then he killed a number of people there, of course. It was an open invitation. Did they have a security guard? Yes, inside the synagogue. That's hopeless. He didn't attack the previous synagogue because that was locked. The second one had no proper security. It was an open invitation. So I don't blame them exactly, but they should think about these things. And you can't say, oh, it's all the, if only people were deprived of gun rights. That wouldn't help either. Criminals, and this is something, of course, that the gun rights lobby always says, criminals always have guns. You can't stop criminals from having guns.
And it seems to be, I don't know if it's a coincidence or not, but it seems to be that a lot of these mass shootings always seem to happen in places where guns are not allowed.
Yeah, well, of course, because the perpetrators don't want to be shot themselves.
Yeah.
Although sometimes they do shoot themselves. But yes, of course it is that way. But it's not properly controlled, like in the cinema in Colorado. That was also a gun-free zone. What good did that do?
Yeah. I just recently moved here to South Dakota from New Jersey. So New Jersey is a highly regulated state when it comes to owning a gun. And South Dakota, pretty much everyone owns a gun and carries with them all the time. I work in an office where every single person in the office is packing all day long. And
I don't think there have been that many murders or mass murders in South Dakota.
I don't think so. Yeah. Because I think it's pretty well known that pretty much everyone here carries. So I think that has a lot to do with, that doesn't mean that there aren't armed robberies. There isn't crime that does happen, but I don't see too many like mass murders, you know, because they know they're going out in a matter of minutes.
Yeah, well, exactly. Yes.
So let's move along. You mentioned before the 9th and 10th Amendment. Real quick, to me, when I read these two amendments, they almost sound like they're saying almost the same thing, or they seem to be very similar.
Yes, they are. Basically, the 9th is saying the rights enumerated here are not all the rights. Do you have a right to pick your nose on the street? Yes, unless there is some local bylaw which prevents that, and sometimes there is. You can, and the same applies to rights. Prohibitions and rights, unless just because this is a constitution doesn't mean this is all the rights you have. And I think that's very important to realize. Doesn't incorporate all the rights, and that's the 9th Amendment. The 10th Amendment is saying the rights here are only to do with the federal government. Anything else, and there are plenty of other rights, those belong to the states or the people. Anything which is not given to the federal government still belongs to the states and the people.
Okay.
And I think that's very important to stress.
But just to be clear, they can still make a law anytime they want with any of these unnamed rights. So
yeah, the feds or
the states or local municipalities. It's not that just because they're not named doesn't mean they're guaranteed. They're not necessarily guaranteed forever, because somebody could write a law at any given point.
No, but the 10th Amendment is saying the rights enumerated here belong to the federal government, but there are other rights floating around. Those belong to the states and the people, and it's up to them. It's up to them. Yes, in some states there are more rights than others. In some states you may have to show ID, photo ID to vote. In others, you may not have to show any kind of ID to vote, and so on. So that's up to the state. So again, that's all part of the federal structure, and I think it's correct that it should be, and I think it's correct to stress that, to realize that the federal constitution is just that. It's a federal constitution. It's not a code of laws for everything you do in your life.
But then through the Supreme Court, with the 14th Amendment used as somewhat of a justification, some parts of the Constitution, namely the first 8 of the Bill of Rights, didn't used to apply to the states, but now they do.
Yes, now they do.
Okay.
And but as I said, some of them already applied as a result of individual
Got it.
individual constitutions, state constitutions.
Got it. I don't know. To me, that's just so confusing, you know. But that's why we have your book to help us figure this out. So let's move on to the 14th Amendment. The 14th Amendment really covers a lot of stuff. I'm reading from your book here, the definition of citizenship, the obligation of the states to uphold privileges and immunities, blah, 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 due process, obligations of state not to deny equal protection, and a whole bunch of other things.
Yeah, one of the things there that's very controversial is whether that amendment actually confers the right to anyone born in the country to be an American citizen. Just to, you know, you're on a tourist visa and you have a baby in America, does that baby automatically become an American citizen? And of course, you have people who do this deliberately, who come to America specifically to have their baby, so that the baby will have American citizenship.
Mm-hmm.
Should that be allowed? Well, according to the U.S. Constitution, or to the U.S. Supreme Court at the moment, that is the position. But whether it should be, whether that's the correct interpretation, I don't know. That amendment is a bit vague, unfortunately. As I say, the 14th, 15th Amendments were drafted by the Little League drafters.
Got it.
Not the same league. They've copied bits from the Fifth Amendment. They've copied bits.
Okay. Now, in the 14th Amendment, the part that says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. And then it goes on and on. So is that the key part that is used to back up the argument that the certain portions of the Bill of Rights applies to the states?
Well, yes, it was used that way. It was used that way.
Do you think that's accurate, or you think that's just the way they interpreted it?
I think it's accurate to some extent, because certainly the 14th Amendment is geared to the states. That's why it says there's no state. It's actually directed, it's addressed to the states, unlike the original Bill of Rights, which is not. The original Bill of Rights is addressed to the federal government.
Okay.
So insofar as that is addressed to the states, I think that may be correct. On the other hand, I think I may have written about this in the book. At the time, one of the drafters of the 14th Amendment was actually trying to pass a separate law in Congress that made the First Amendment applicable to all states. So he didn't seem to think the First Amendment already applied to the states, because he was bringing in a separate law for that, a separate amendment. He wanted to actually bring in a separate amendment that made the states recognize the First Amendment. Well, if he thought that, and he was one of the drafters of the 14th Amendment, means he didn't think the 14th Amendment included that. But the Supreme Court subsequently felt that it did.
Yeah.
I don't think there's any way of going back on it anyhow. I think
at this point, right? So
done piecemeal.
Yeah.
Bits and pieces here and there, but now we're at a stage where, as I say, except for those two little exceptions in the Fifth Amendment, the whole of the first 8 now are applicable to the states as well as to the federal.
Okay. So this is the last question I'm going to ask about the dynamic between the federal government and the states. I know I've kind of dwelled on that a little bit, but it's kind of, for me, it's just like an ongoing conversation that I have with people on Facebook. So I tend to prefer the Constitution having as little bearing as the states as possible. Do you
Yeah.
think the incorporated Bill of Rights is actually better for individual liberty, states' rights, and small government, or worse?
Well, I think because of the very broad way in which the those rights are now interpreted, it probably isn't so good. On the other hand, it would be a mess if you had, say, for example, abortion rights recognized in one state and not in another state. That would make a mess. And it was the case before Wade versus Roe. There were 46 states which had laws prohibiting abortion. All those 46 state laws were declared unconstitutional by the Supreme Court in Wade versus Roe. 46 of the 50 states. Now, there have been attempts by some states to introduce, as it were, by the back door, some restrictions on abortion rights, without entirely reversing Wade versus Roe. And with a greater number of conservative justices on the court, there is speculation that some of those states to prevail, but so far they haven't. But there are now more conservatives on the court than ever, well, not for a long time anyway, because, of course, of the three Trump nominees. This is probably the most lasting of Trump's legacies, is his three nominees to the US Supreme Court, which was quite a coup for him. I don't think Ruth Bader Ginsburg was planning on giving Trump the right to choose her successor.
Mm-hmm.
She was planning on retiring at the age of 90, like John Paul Stevens, but it didn't quite work out for her. She would very much have liked to stand down when there was a Democratic president in the White House, but that wasn't a choice given to her.
Sure.
And so as a result of that, there are now three conservative justices, plus the two who were already there, Clarence Thomas, of course, and Alito, which is a majority. 3 plus 2 is 5 out of 9. And John Roberts used to be thought of as a conservative. Now I would say he is more of a swing vote, and he has been siding with the liberals on quite a few occasions. I think he likes the idea of unanimity, which is very rare. Actually, it's not as rare as people think, because on a lot of unimportant cases, or cases that don't affect a lot of people, there is unanimity, actually. So that's wrong in a way. But on these very, very contentious matters, there isn't. And of course, there is the proposal by some Democrats to pack the Supreme Court. In other words, to enlarge the number of Supreme Court justices. And is that something that they could do? The answer is yes. The Constitution does not specify how many justices there should be.
And that almost happened under FDR, right?
I wouldn't say it almost happened. He wanted it to happen because a lot of his legislation, New Deal legislation, was being struck down by the Supreme Court, 5-4 decisions, as unconstitutional. And he got livid about that, saying that these people cannot impose their economic people, because he had a massive majority in Congress and as president. He said, as he put it to the country in one of his radio addresses, fireside chats as they were called, the government is made up of three. It's like three horses pulling the government. Two of the horses are pulling together, and one isn't. And that one is the Supreme Court. And this can't be allowed to continue. And he had a plan whereby once a justice turned 70 and a half, I don't quite know why there was the half, he as president would have the right to nominate an extra one. There was no limit on the number. Of course, that would have resulted in a majority for him. But as it turned out, it wasn't necessary, because a different Roberts, not John Roberts, but another Roberts, who was on the court at the time, switched sides. And the phrase was created by the press, a switch in time saved nine.
Yeah.
The nine justices.
So it was more of a threat than anything.
Well, he would have gone through with it had it not been for the fact that Roberts switched sides.
Yeah.
Owen Roberts. But there's a bit of a debate about whether he was planning to, whether FDR knew about it beforehand, whatever. But in fact, Congress threw it out. Congress, even though he had a huge majority in Congress, he was not supported by Congress, and his own vice president was against it, Garner. Not that that matters much.
The imperial president, as they called him.
Yeah. Well, it's 1869. The number on the Supreme Court has been 9. But prior to that, it did fluctuate a lot. Initially, it was 6, then it became 5, then it became 6 again, became 7. But only since 1869, well, I mean, that's a long time ago, obviously, but since 1869, it's been 9. Obviously, got to be an odd number, otherwise you're going to have a tie a lot of times, which you don't want.
And they were accusing Biden of having plans to pack the court once he became president, and he never really. I don't think he ever came out and actually said one way or the other.
I don't know if he did, but certainly some of his supporters have done. I think because they were stung by the fact that there were these 3 extra conservative justices. I mean, what is particularly sad, though, in a way, is that there are these 2 very, very diametrically opposed interpretations of the Constitution. Because for the most part, the rest of the law in America is not like that. In state courts around the country and so on, there's no big difference of opinion on the law, unlike in Britain where there is, because there's no codification, and it's actually in a very terrible state. And I've written about that in the book called Anglo-American Law, a comparison. You have cases all the time with politics where there are complete differences of opinion on what the law is, and it really makes for a real dent in justice. You can't have justice where there's constant disagreement amongst the judges and there's no understanding of what the law actually is. In America, that's not the case, except at the very highest level, unfortunately, in the Constitution.
Yeah.
But who's going to say anything else? The Chief Justice hasn't the authority to say, now look here, from now on, this is the interpretation. He hasn't got that authority. Nobody has. Nobody has.
And if we were to have some type of a constitutional convention to like rewrite the Constitution, that would probably wind up, we'd wind up in a worse situation, most
That
likely.
wouldn't be
So
any different because that's always any constitution is always going to be open to interpretation.